Tonight on the Daily Debrief, an actor is under arrest. Police are fuming.
I'm offended by what's happened, and I'm also angry.
Did he stage his own attack to raise his profile and his salary? Plus, a legal loophole allows an attorney to testify about her client's fears.
She said that Brian sent one of his men over to scare me.
Did the client name her own killer? Also, a court says federal prosecutors broke the rules by giving a sweetheart deal to a billionaire accused civilly of sex crimes. And a problem pops up with the conviction of drug cartel leader El Chapo. The nation's top criminal cases are on the Daily Debrief. It's Thursday, February 21st. Good evening, everybody. Glad you're with us tonight. Aaron Keller here on the Debrief along with attorney Anthony Pope. He wanted sympathy and wound up in jail. Television actor Jussie Smollett is under arrest on charges that he paid two men to fake an attack on himself. Today's charges came after a twisted series of events.
This publicity stunt was a scar that Chicago didn't earn and certainly didn't deserve.
With those words, Chicago police announced the arrest of Jussie Smollett. The actor, most famous for his role on the TV series Empire, is accused of disorderly conduct for falsely reporting an attack Smollett says happened to him in Chicago.
This stunt was orchestrated by Smollett because he was dissatisfied with his salary.
The events unfolded after Smollett pleaded for sympathy on national television.
I get threatened all the time. They called me a They called me a
Police released this possible image of the two assailants Smollett claimed had thrown a chemical substance on him, used a noose to attack him, and yelled racial and homophobic slurs. But they say the story never made sense.
First, Smollett attempted to gain attention by sending a false letter that relied on racial, homophobic, and political language. When that didn't work, Smollett paid $3,500 to stage this attack and drag Chicago's reputation through the mud in the process.
The evidence includes phone calls between Smollett and the two men who have apparently admitted playing a role in what police are now saying was a fake attack. Police are not accusing them of anything.
I classified them no longer as suspects or persons of interest and as witnesses.
The charges are a fourth-degree felony, and police are left shaking their heads.
Why would anyone, especially an African-American man, use the symbolism of a noose to make false accusations? Bogus police reports cause real harm.
A judge this afternoon set Smollett's bail at $100,000 and forced him to surrender his passport. Smollett's show, Empire, is produced by 20th Century Fox. Fox says it's considering its legal options as this criminal case moves forward. Day two of testimony in the Kentucky trial of a janitor accused of murdering his coworker. David Dooley is facing his second trial regarding the death of Michelle Mockbee. The lead investigator who worked the original case was having an affair with the original prosecutor who handled that first trial. The first prosecutor also failed to turn a surveillance video over to the case. Dooley and his wife both worked at the facility where the victim died. The state says the motive was that Dooley's wife was submitting time cards for time she did not work. Fearing the victim would put an end to it, the state says he killed the victim. First, the 911 call from the manager who found the victim's body.
I just walked in her office and I think somebody had killed somebody upstairs in her office.
Okay. What makes you think somebody killed somebody?
She's laying there on the ground, covered up, and there's blood all over the floor in the office.
Okay. What's the address there?
7383 Empire Drive.
Okay. Is it somebody that worked there? Or?
Yeah, it looks like her name is Michelle Mockbee. She usually comes in early on Mondays, and they got her, like her whole body's covered with plastic in that, so you can't see her head or anything.
And it is obvious she's dead, right?
Yes, sir. Yes, ma'am.
Okay, how long's it been since somebody was in there?
5 o'clock we have people come in. Usually Michelle on Mondays gets here at 7 o'clock.
Okay, so there were people there yesterday?
No, nobody was in here yesterday at all.
Okay, so this morning, and so the last time somebody would have been there would have been last Friday?
Friday, yeah, and they would have left around 8 o'clock at night.
Was that her office?
No, no, she's on the outside. We have a mezzanine. Well, the blood is right by her office door. It looks like she never got in her office.
She didn't, so she couldn't have jumped?
No, ma'am.
Let hands tied behind her back?
I think that, oh, she's no
Okay.
shoes on. They're, like I said, and they had somebody covered her body with plastic or something.
Okay, and you said there's blood outside the office door?
Yes, ma'am. A big pile of blood.
A major with the local sheriff's department said he had to separate witnesses for interviews. When that happened, he said the defendant started behaving strangely.
You want people to be able to give their statement based on what they remember, what they recollect.
And not what the group thinks, right?
Correct.
Okay, so who were the people that you decided needed to be separated?
One was Ed.
Why Ed, by the way?
Ed made the statement that he had seen the spot and then had further investigated because he made the statement that they didn't know if somebody had cut themselves on the floor. It's a packaging company, so once they saw that red spot that was on the floor in that hallway on the upper level, him and the maintenance, then they basically started to investigate further, and that's when they came across the victim.
Okay, so that's why we separate Ed.
Yes.
Who else did you separate from the group?
The gentleman that was listed as maintenance, he was separated, and then there was a third, David Dooley, was listed as a janitor.
You made the decision to separate these three people out, correct?
Correct.
Okay. And David Dooley was one of those three, correct?
Correct.
Okay. Let me ask you, were there any observations that you made of Mr. Dooley when you asked that he be separated from the rest of the group?
Mr. Dooley acted a little, resistant at first. He didn't appear to want to leave the rest of the group of employees that were gathering again in that front lobby area.
During opening statements, the prosecution said surveillance cameras caught the defendant making some bizarre moves the day of the murder.
The day of the murder, he gathers up the surveillance footage. What does he see? There's everybody coming to work. Okay, everybody checks off. About 30 minutes after Michelle's death, about 6:30 in the morning, guess who's seen leaving? David Dooley. And he's not just leaving. He parks here. He should go out here. That's the way he goes. We looked at a month of surveillance. He goes in and out this way every single time. But 6:30 in the morning, 30 minutes after Michelle Mockbee had been beaten to death, he gets in his truck and he goes all the way around here. Think he didn't want to be seen? Go ahead, Jeff. This is a still of David Dooley's truck going behind Thermo Fisher and Beckman Coulter. Now, go ahead, Jeff. Now, the police reached this conclusion. And ladies and gentlemen, the evidence in this case is going to be, I think you're going to be satisfied. Whoever did this left. Items that were used in Michelle's murder to this day have never been found at that warehouse. Items like the tape gun that bound her wrists. Items like the blade that cut her wrists, which I forgot to mention. Her wrists were cut. Her skull was fractured. Some blunt object was used to beat her to death. These items were never recovered. We think whoever did this left.
The state says David Dooley gave conflicting stories about why he left work. First, he said nothing about leaving. Then he told police his wife wasn't feeling well. Then he told a coworker he left because he ripped his pants. The defense rebutted the prosecution's suggestions about the significance of any of that or the surveillance footage.
Once the surveillance video came out and they found that he had left, that was a big deal. It was a huge deal because if somebody left around about, it's like 6:31, maybe that person could be the killer. And the evidence will show that the absolute focus in this investigation became David Dooley because he left. So they hightailed it out there to his house. I mean, this guy, there's no evidence that you're going to hear that he left, that he ran away. He came back to the facility to finish his job. But the police officers came, the two detectives, and they interviewed him. And despite what the prosecution said, he volunteered, ladies and gentlemen of the jury, he volunteered to them that he left. He said, oh, by the way, before they even asked him, I forgot to tell you yesterday, I left you.
Two sides to the story there. Joining me tonight is attorney Anthony Pope. He's in studio with us tonight. Good to see you.
Oh, thank you. Nice to be here.
So what do you make of this? This state is saying that the motive here is the wife clocking for time that she didn't really work, and the defendant gets all upset about the possibility that the victim is going to catch this husband and wife in this scheme. Does this make sense?
You know, it's a stretch. It's a real stretch. To kill somebody and bludgeon somebody the way this woman was under those circumstances, you know, a jury's going to look at it very skeptically, as they should any motive. But they don't seem to have a lot here. So they're going with whatever they have. Even with when he left or how he seemed to be peculiar in the way he acted, well, it's a strange thing. If you've never been interviewed by the police and there's a dead person there that you might know or a co-worker, people don't always act the normal way or the way you might expect it. So it is what it is. You know, it's going to be one of those things the jury's going to have to decide, but I certainly haven't seen a smoking gun here.
Okay, it makes me nervous, too, when prosecutors get people up there on the witness stand and say, oh, well, he was behaving differently from other people. Because, look, I mean, we don't know how we would react in a situation like that.
That's exactly it, yep. That's true. And what they do is they second guess everything. They play Monday morning quarterback, have an opportunity to sit back, reflect on what occurred, and then they try to look for something. See, if you draw a conclusion and you try to back into that conclusion, then with all of us, anybody that's ever been interviewed, you'll find something. The way you looked, you turned away from me. You did something with your tie, you moved the wrong direction. I mean, there's something you can always pick out that may be a little suspicious or peculiar. And when you have investigators that's their job to look for it, where they're going to find the most minute thing and try to make more of it than it is.
Yeah, the surveillance recording may be the key piece here. A lot to come. Attorney Pope, we'll check in again with you at the end of the broadcast. Okay. The criminal trial of an accused Mexican drug cartel leader, El Chapo, ended in a conviction, but that might be in jeopardy due to reports of juror misconduct. Chief investigative correspondent Brian Ross is in the newsroom to explain just what's going on here. Brian, good evening.
Well, good evening, Aaron. This is a bombshell report by a reporter for Vice who apparently talked to one member of the jury. It was held in great secrecy there. He says members of the jury regularly ignored the judge's orders not to do their own research, not to go on Twitter, not to do research on allegations against El Chapo, including one allegation that was published in the New York Post about El Chapo's lawyer having an affair with another woman.
A lot to tear into there. I can't wait for the motions to throw the case out and start again. We expect those to be coming any day.
Likely to come. He's facing life in prison, so anything, and this gives them something that shows complete, it seems to me, jury misconduct.
Exactly. Brian, you covered El Chapo recently on Brian Ross Investigates, but a new episode's coming up tonight, so what's in store tonight?
Well, tonight we're focusing on something called the U.S. Freedom Army, a supposed group of patriots, American patriots. What we discovered is that it's being promoted and secretly backed by Russian internet bots operating out of St. Petersburg, trying to promote and essentially amplify the message. As a result of our investigation, Twitter has now suspended their account. More on that coming up, Aaron.
Brian, can't wait to watch that episode coming up at 5:30 right here on Law and Crime. And still ahead tonight on The Debrief, billionaire Jeffrey Epstein accused of sex crimes but never prosecuted because of a sweetheart deal. That all might change after a federal judge's order. Plus, who killed a Florida mother? An attorney testifies about the victim's fears prior to her death thanks to a rule of evidence. We take you back inside the courtroom after the break. Welcome back to The Debrief, folks. After years of shady legal dealings, federal prosecutors may finally be able to go after an accused sex ring leader after they originally declined to do anything about him. Billionaire Jeffrey Epstein struck a sweetheart deal with the U.S. Attorney for the Southern District of Florida 12 years ago. He agreed to plead guilty to state prostitution charges in exchange for avoiding federal prosecution. Today, a federal judge ruled that prosecutors violated the law when they struck that sweetheart deal with Epstein. Court records accuse Epstein of running an underage sex ring out of his private plane and his South Florida mansion. He served just 13 months in a county jail and got home detention for procuring minors for prostitution. Testimony is revolving around DNA evidence at a California murder trial expected to last months. Charles Merritt is accused of murdering his business partner, Joseph McStay, and McStay's entire family. The prosecution says the motive was money. The family disappeared in 2010. A dirt biker found all of their bodies buried in the desert in 2013. The McStay family SUV turned up near the border with Mexico not long after the family disappeared. And all through this case, we have heard that the defendant's DNA was in the McStay family SUV. This week, the state's DNA analyst said the defendant was only a trace contributor to one sample and a minor contributor to another. Merritt did not turn up in any of the many other samples. The defense believes the DNA came from a handshake between Merritt and McStay before the family disappeared. The analyst, though, stuck by his findings.
All I knew was that I had reference samples that were submitted that I was to compare to these particular profiles. It so happens that one of those reference samples was from Mr. Merritt. I had no idea who he was. Simply, I reported my results in February. Basically, I took into account the 7 reference sample profiles that I had at hand.
Testimony in the McStay case moves into the evening. You can watch it on lawandcrime.com. A Florida murder trial is entering its second day today. David Russell Holbrook Jr. is charged with murdering a mother of 3 back in 2006. Authorities say victim Melissa Howard was stabbed and beaten. She had just won a child custody battle against her ex-husband, Brian Howard. The defendant was Brian's friend. The ex-husband himself has an alibi for the time of the killing. In court today, an argument over evidence. The victim's attorney was prepared to testify that the defendant had gotten into the victim's house days before the victim was stabbed to death. The defense objected by saying the victim's statement was hearsay, a statement by someone not testifying and therefore not subject to cross-examination. The state argued that a narrow exception for excited utterances should allow the attorney to testify about what the victim said on the phone.
The Supreme Court has indicated that the burden is on the offering party to demonstrate that the declarant, meaning the person who made the statement, did not engage in reflective thought. That is my understanding of the law of the state of Florida.
The common thread in the cases that allow the excited utterance, and it's when someone is hysterical, severely injured, or in an extreme emotional state sufficient to prevent reflective thought. The fact that the victim was already crying, was already talking quickly, and got faster and faster shows the extreme emotional state that she was in. In that state, she does not have the capacity for reflective thought.
Did she have the capacity to reflectively think about the situation prior to the phone being dialed?
I don't believe so because of the testimony that he just left. The judge, we have met those 3 requirements. It was regarding the event that was startling enough to cause nervous excitement. It was before there was time to contrive or misrepresent what was going on. And it was while the person was under the stress or excitement caused by the event.
Very narrow exceptions for this type of evidence. Florida's is more broad. The judge allowed the testimony into the trial about that phone call between the victim and the attorney. Here it is.
What did she tell you was the reason that she was so upset?
The first thing that she said to me was, I knew this would happen. And I asked her, what did she mean by that? And she said that Brian sent one of his men over to scare me. I asked who it was, and she told me who it was.
How did she identify the person that had done this?
Well, right after she had answered the phone, she said he just left. And then she said, I knew he would do this. I had made an assumption that it was Brian. That's why I said, who was it? And she said that it was Russell.
Did you inquire who Russell was referring to?
I already knew who Russell was based on our prior conversations. However, I did ask her to specify exactly who she was talking about.
Did she?
She did.
And what did she say?
She used his full name. She said David Russell Holbrook.
Did she say what Russell told her during the course of the visit? I mean, why? How does that relate to what was going on in Melissa Howard's life?
That was the 4th of January, and beginning on January the 6th is when Taylor was supposed to start living with her on a primary basis, and she told me that what Russell told her was, you need to let that boy be with his father, and you need to let this go.
That was the key testimony. Let's turn again now to attorney Anthony Pope. So what do you make of the judge's decision, to allow that into the trial? I said Florida's got a much broader excited utterance rule. They basically allow things in if the person is still shaken by what they saw. Now, the federal rule in some other states say you have to basically be doing play-by-play describing something. Yes.
Exactly, yeah. Well, it is broad, and it depends on what judge you get. Some other judge probably would have ruled against it. This judge ruled in favor of it. I didn't hear anything that would constitute an exception to the hearsay rule in New Jersey or in the federal courts. So Florida, with the broad interpretation, as they are, the prosecution got to win.
This is one of these things that I think is interesting sitting here because, look, in some states, this wouldn't get in, and it would possibly change the outcome of the whole trial because here's someone who the jury is probably going to believe it's an attorney, okay, who has taken multiple oaths to tell the truth, okay. Her practice could suffer if she's lying. She could be disbarred if she's lying. She's getting up there saying, my client told me this guy got in the house and made these threats, and then days later, she turns up dead.
Especially in a case where there's not a lot of evidence. You have no eyewitnesses. You don't really have much DNA. So you don't have anything really that corroborates it. So you're leaving the jury with this impression that the man went over the house, he threatened her, and now she's dead.
Now there's that sweater, though. They've got a little bit of the defendant's DNA on that sweater or a sweatshirt there. And he's saying, well, that's there because I admit to being in the home in the instance that the attorney's testifying about, but I didn't do anything else. It's just a trace amount.
Yeah, and that happens a lot of times. I had a case in November in federal court with DNA. And the DNA of my client was in the back seat, and it was the DNA expert could not say whether it was a fluid, exactly a hair, but it was a combination of things.
And if it's just a little bit,
and it's just a little bit, all of a sudden your client's there. Now we didn't deny it, but the prosecutor tried to put him in the front seat driving the car, and there was no evidence there. So, but it could change the whole thing. You know, a little bit of evidence like that.
We've got to wrap up the broadcast, though. Attorney Pope, good to have you on. That's it for the Daily Debrief tonight here on Law and Crime. I'll see you back here tomorrow.